common question under the new state privacy laws is how these laws apply to loyalty programs, where retailers provide consumers with discounts or other rewards based on repeat business. If you've been following along with McDermott's state law privacy video series, it may come as no surprise to learn that the way that California treats these loyalty programs differs significantly from the way these programs are treated under the other new laws in Colorado, Virginia, and Utah. In particular, a recent enforcement sweep in California highlights how businesses that operate loyalty programs in that state need to take a close look to ensure that they are in compliance with California law. Let's take a quick look at the other states first. In Colorado, Virginia, and Utah, each of the new privacy laws contains a provision that bars companies from penalizing consumers for exercising their consumer rights under these laws, rights such as the right to access or delete their data. However, in all three states, these so-called non-discrimination provisions also contain express exemptions for loyalty or rewards programs. So, operators of standard loyalty programs in these states likely don't need to do anything special to comply. As long as these loyalty programs are brought within your overall privacy program, they should not create any special challenges under the new laws in Colorado, Virginia, or Utah. In California, the CCPA, which is the currently effective law, contains a similar non-discrimination provision as the other states. And, starting next year, the new CPRA will amend the CCPA to explicitly exclude loyalty programs from this provision, just like the other states. However, this exclusion will not extend to the related but independent requirements under the CCPA, which govern financial incentives. And financial incentives includes the offering of a discount in exchange for the collection or retention of personal information. In fact, the California Attorney General's Office recently conducted an enforcement sweep under these rules that specifically targeted loyalty program operators. The details are not public, but it appears that the California AG has taken the position that all loyalty programs in California constitute financial incentives under the CCPA. Now, it's worth noting that the California AG's position is not clearly correct. Loyalty programs offer discounts in exchange for repeat business, not often in exchange for data. So, many companies that face enforcement may have reasonable arguments that this activity is not, in fact, subject to the financial incentive requirements. That said, companies who want to avoid becoming an enforcement test case should strongly consider complying with the financial incentive rules with respect to their loyalty programs. Financial incentives under the CCPA are subject to a number of unique requirements, including a requirement to obtain opt-in consent, and, under the CCPA regulations, to provide enhanced notices to consumers. These notices must include an estimate of the value of the data and how that value was calculated. Estimating this value is especially challenging in the context of loyalty programs, and companies should carefully consider their options to pick the right approach and minimize any associated legal risks that are related to this calculation. If you like this video, check out others in the series, including the upcoming discussion of enforcement under the new state laws. Thanks for watching.